My cousin sent me a certified letter informing me that the business had been transferred to him. The letter was from his attorney, and it was written in the specific formal language of letters that are designed to sound like finished facts rather than opening moves. It said that pursuant to the operating agreement of Dalton Street Print and Design LLC, my cousin Stefan had acquired full membership interest in the company following my father's death, and that I had no remaining interest in the entity. It said this clearly and without ambiguity, and it included a copy of an Ohio Secretary of State filing showing the membership transfer, and it included a signature page that showed my authorization of the transfer. The signature on that page said Lara Kovacs. I have not been Lara Kovacs for 6 years. I legally changed my name to Lara Brennan in March 6 years before my father died. The change was recorded with the Cuyahoga County Common Pleas Court and filed with the Ohio Bureau of Motor Vehicles and the Social Security Administration and reflected in every document I had generated since. I had not signed anything as Lara Kovacs since the week before the court approved the change. The signature on the transfer authorization that Stefan's attorney had sent me was not mine. It could not have been mine, not because I disputed the handwriting, but because the name under the signature line was a legal name that had not existed for 6 years. Before I go on, if this story connects with something real in your life, please take a moment to like and subscribe, but only if you genuinely feel it. Drop a comment and tell me where you are watching from and what time it is there. I read every single one. My name is Lara Brennan. I am 29 years old. And this is the story of how a court-approved name change record from 6 years earlier, a filing with the Ohio Secretary of State, and a business attorney named Owen, who understood exactly what a signature under a defunct legal name means, became the chain of public documents that gave me back my father's print shop. Now let me take you back to the beginning, not the certified letter, before that. To the shop on Dalton Street in Cleveland that my father had run for 23 years, and that had been, in the way that small independent businesses are for the people who build them, not just a business but a kind of proof. Proof that he had built something that lasted. Proof that his particular combination of precision and warmth and specific knowledge of what his customers actually needed had a sustainable form. Proof in the specific sense that a business entering its 3rd decade is proof that the thing he started was real. My father's name was Gregor Kovacs. He was 68 when he died. He had been born in Hungary and had come to Cleveland at 24 and had spent 4 years working in other people's print shops before he had saved enough to open his own. He ran it with the specific devotion of someone who has built something from actual savings and who understands what it would mean to lose it. He had a quality of unhurried precision in everything he did, the kind that comes from having decided that doing something correctly once is more efficient than doing it quickly twice. He applied this to the printing, to the customer relationships, to the maintenance of the equipment, to the bookkeeping, to the hiring of the 2 employees who had each been with him for more than 8 years. Stefan is my father's sister's son. He is 36 years old, and he has been involved in the periphery of the business for most of his adult life in the specific way that a family member becomes involved when the business owner is trusting and generous, and when the family member is capable of appearing helpful without doing the actual work of the business. He had helped with deliveries at various points. He had managed the social media account for about 18 months in his late 20s, which mostly meant he had credentials to platforms that my father had not had the interest or energy to manage himself. He attended family events. He called my father uncle with the warmth that blood relatives use for words that are also strategic categories. I changed my name 6 years before my father died for the specific reason that I had wanted for a long time to carry a name that reflected who I was, rather than a name that connected me to a part of my history that no longer felt like mine. I will not go into the full particulars here because they are not relevant to the legal story, but I will say that the decision was clear and considered, and that the process involved a formal petition to the Cuyahoga County Common Pleas Court, and a waiting period, and a hearing, and a judge's signature on a court order and a certified copy of that order, which I had carried in my documents folder for 6 years, and that I could put my hands on within about 30 seconds of wanting to. The change was also reflected in my Ohio driver's license, my passport, my social security card, my employer records, my tax filings, my bank accounts, my lease, and every other document in my life that carried my name on it. I have not been Lara Kovacs since the week before the court approved the change, and that was 6 years ago. My father died in October. He had been diagnosed with a cardiac condition 2 years earlier, and his decline was gradual and then rapid in the specific way of cardiac conditions that progress to their conclusion. I was at his bedside, and I held his hand at the end, and I drove home afterward in the silence that follows the largest things. The funeral was attended by people who had known him for decades, customers who had become friends, employees who had worked for him, and who spoke about him with the particular warmth of people who know what it is to work for someone who treated them correctly. One of my father's employees, a woman named Camille, who had been with him for 9 years and who ran the front desk with a combination of efficiency and cheerfulness that my father had told me more than once, was the reason the customers came back. Came to the reception afterward and said, "Your father talked about you taking over the shop every time things were going well." She said he said it with the tone of someone planning for a future he was glad about. The will had been prepared properly. My father had a business attorney named Owen Park, whose office was in Midtown Cleveland and who had drawn up both the personal will and the business succession documents. The will was explicit. The LLC interests passed entirely to me. The operating agreement had been updated 3 years before my father's death specifically to document this succession. Owen had a copy. I had a copy. My father had kept his copy in a lockbox in the shop that his employees knew about and that I had the key to. Everything was documented correctly. I had every reason to expect that what my father had spent 23 years building would be managed through the proper legal channels in the proper sequence. The certified letter arrived 11 days after the funeral. I read it twice. I looked at the signature page. I looked at the name under the signature line. I looked at it for a long time with the specific stillness of a person who has just seen something that contains more information than it appears to contain on first reading. Lara Kovacs. I had not been Lara Kovacs for 6 years. I called. I want to tell you what reading the certified letter was like the first time and then the second time. The first time I read it, the way you read a thing when you are not expecting what it says, which is to say faster than you should, and in the specific disbelief of a person whose understanding of the current state of things is being actively revised by the words in front of them. I read that my father's business had been transferred to Stefan, and I read that I had no remaining interest, and I read the formal legal language of a letter that was designed to convey finality, and I felt the specific weight of that language in the way you feel language that is trying to establish a reality you have not agreed to. Then I read it a second time, more slowly, and on the second reading I found the signature page. I looked at it. I looked at the line under the signature. Lara Kovacs. I read that name and I felt something shift in the quality of what I was experiencing. The first read had been the experience of a person being told something is finished. The second read was the experience of a person who has found the specific place where the finished thing is not finished at all. I put the letter down. I said the name out loud in my apartment in the specific way you say something out loud when you need to hear whether it sounds like what you think it sounds like. Lara Kovacs. I had not heard that name applied to me in 6 years. It did not sound like me because it was not me. It had not been me for 6 years. I picked up the phone and called Owen. Owen answered on the second ring. He listened without interrupting. When I finished, he said 2 words. Send everything. I sent it. He called back in 40 minutes and said, "I want to tell you the most important thing first." He told me. I listened. I understood. We began. Owen Park within the hour. Owen listened to what I described without interrupting. When I finished, he said 3 words. Send me everything. I sent him the certified letter and the attached documents. He reviewed them and called me back in 40 minutes and said, "I want to go through this carefully, but I am going to tell you the most important thing first, which is that a signature under a legal name that the signer has not held for 6 years is not a valid signature for the purposes of a legal business transfer." He said the operating agreement and the LLC formation documents and every state filing related to this business carried the name Lara Kovacs because that was the name I held when those documents were created years before I changed my name. He said it was therefore a plausible error for someone who was trying to forge an authorization to use the old name because it appeared in the business documents. He said it was not a plausible error that survived contact with the Ohio name change records, which are public, which are searchable, and which show definitively when Lara Kovacs ceased to be a legal name. He said the Ohio Secretary of State filing that Stefan's attorney had submitted showed a membership transfer authorized by Lara Kovacs. He said, "I can show that Lara Kovacs has not been a legal name for 6 years through a public court record." He said the authorization is therefore not a valid signature by any person who currently holds legal standing to authorize a transfer. He said this is a clean case from a documentary standpoint and a complicated case from a family standpoint, and we are going to need to move quickly because a fraudulent filing with the Secretary of State is a live document that exists and is creating legal uncertainty about the ownership of the business right now. Owen filed an emergency application. I also want to tell you about finding the name change document in my files. Owen had asked for it and I knew where it was. I have a specific system for legal documents that I developed in my mid-20s when I realized I was losing track of papers that mattered, and that the solution was to have a single place and a single system, and to put things in it when they arrived and not to put them somewhere else first. I have a folder on my laptop labeled Legal Documents with subfolders by category. The subfolder for identity documents contains the court order for the name change as a scanned PDF with the date in the file name. I had not opened that file in more than 4 years. I had not needed to. I knew it was there, and I had known it was there the entire time. And when Owen said I need the name change record, I opened the folder and the file was there with the date in the file name, and I emailed it to him in about 45 seconds. He called me back within the hour with his assessment. The 45 seconds it took me to find and send the document were 45 seconds that existed because I had a system and because 6 years earlier I had put the document in the system when it arrived and not somewhere else. I am not saying this because I think I am unusually organized. I am saying it because the difference between being able to find a document in 45 seconds and being able to find it in 2 weeks of searching or not being able to find it at all is not a difference in intelligence or legal sophistication. It is a difference in habit. The habit exists or it does not. If it exists, the document is there when you need it. Mine existed. The document was there. With the Cuyahoga County Common Pleas Court to void the transfer filing on the grounds of fraudulent execution, he submitted the Ohio Secretary of State LLC transfer filing. He submitted my court-ordered name change document, certified, showing that Lara Kovacs had ceased to be my legal name. He submitted my Ohio driver's license in the name Lara Brennan dated 6 years prior. He submitted my Social Security record showing the name update. He submitted the original LLC operating agreement showing the succession to me under the business documents that predated my name change. He submitted the updated operating agreement my father had had Owen prepare specifically naming me as successor. He submitted a sworn statement from Owen regarding the succession documents he had prepared. He submitted a sworn statement from Camille, the shop employee, attesting to my father's stated intentions regarding the business succession. The application also included a request for a temporary restraining order preventing Stefan from accessing or operating the business or its accounts until the matter was resolved. The judge granted the temporary restraining order the same day. Stefan's attorney filed a response arguing that the transfer had been validly authorized and that any name discrepancy was a minor administrative issue reflecting the business documents. Owen's reply was 8 pages. It addressed the minor administrative issue framing by pointing out that a name someone has not legally held for 6 years is not a minor administrative issue in the context of a signature authorizing a major legal transfer. It noted that the Ohio name change record is not a clerical anomaly. It is a court order. A court order does not become minor in retrospect because someone has forged a signature under the name it removed. The hearing was on a Wednesday morning 6 weeks after the initial filing. The judge was a common pleas judge named Sandra Merritt, who had the particular quality of a judge who has spent years determining what documents say and who does not require dramatic presentation to understand that a document signed under a name that ceased to exist 6 years earlier is not a valid document. She asked Stefan's attorney one question directly. Can you explain why the authorization signature uses a name that the Ohio records show was legally changed 6 years before the date of the signature? Stefan's attorney said the business documents carried that name and it was reasonable to use it for business continuity purposes. Judge Merritt said the business documents carrying a previous name do not authorize a person to sign under that name 6 years after it was legally changed. She said it is the name change record that establishes the legal identity of the signer, and the name change record says the signer of this document does not exist. She ruled from the bench. She voided, I want to tell you something about the hearing itself beyond the legal summary I gave earlier. I arrived at the Cuyahoga County Courthouse on the Wednesday morning with Owen, and we sat at the petitioner's table, and I looked at Stefan for the first time since before my father had died. He did not look at me when I came in, and I did not make an effort to make him look at me. The specific quality of being in a room with a person who has done something to you and who is also present in your family's history and who has attended events that you remember warmly is a specific kind of complicated that I had prepared for, and that was still more complicated in the actual room than in the preparation. Owen had told me before the hearing that judges in cases like this often understand the situation quite quickly, and that the hearing may be shorter than I was expecting. He was right. Judge Merritt had clearly read the filings before she sat down. She looked at Stefan's attorney and asked the one question, and his answer was the answer of someone who does not have a sufficient answer. She set her piece on the record about the defunct legal name not being a business continuity issue, but a legal identity question. She ruled from the bench. The whole hearing was about 40 minutes. Owen and I walked out into the hallway and he said that went as expected. I said yes. He said, "Let me know when you want to do the formal transition of the business records to your current legal name." I said soon. He said, "I will prepare the documents." We shook hands and went to our separate cars, and I sat in mine for a few minutes thinking about 23 years of my father's careful work being exactly where it was supposed to be, and me being the person going back to it. The Secretary of State transfer filing in full. She ordered the business interest restored to the estate for proper administration under the terms of the will. She referred the matter to the county prosecutor. She said on the record that the use of a defunct legal name on a transfer authorization is not an error. It is a choice. The choice was made by someone who knew the name was in the business documents and who believed it would appear valid without investigation. The investigation took approximately 6 weeks and a name change record that had been sitting in a court file for 6 years waiting to be useful. The business is mine now. Dalton Street Print and Design. Camille is still at the front desk, and the 2 employees my father had kept for 8+ years are still there, and the equipment is still running, and the customers who have been coming for decades are still coming. I have been going in every day for the past 4 months. I am learning things I did not know before. The specific knowledge that comes from being present in an operation rather than adjacent to it. The understanding of what my father knew when he said doing something correctly once is more efficient than doing it quickly twice. I hear him in the shop sometimes in the form of how the employees describe his approach to specific problems, and I find that I am trying to approach the same problems in the same way. Owen is still my business attorney. He said to me after the ruling that this was one of the cleaner cases he had seen from an evidentiary standpoint. He said the name change record was the rare piece of evidence that is both completely definitive and completely simple. He said there was no interpretation required. It was a court order saying this name ceased to exist on this date, and a forged signature using that name, and the date of the forged signature was 6 years after the court order. He said he had explained this to the judge in one paragraph, and the judge had understood it in one paragraph, and the ruling had followed from that paragraph. He said most cases do not work that cleanly. I said, I know I was fortunate. He said you were fortunate that you had the document. He said many people do not have the document because many people do not keep them. I said I kept mine because it mattered to me. He said yes. He said it also mattered in this context. Stefan and I have not spoken since I want to tell you about my father's hands because I have been thinking about them since all of this happened. He had the hands of someone who had done physical work for a long time, not rough in the agricultural sense, but specific in the way that hands get specific from handling equipment and materials with care and precision for decades. He could feel the difference between paper weights by touch. He could identify problems in a print run by looking at the output the way a musician can hear something slightly off in a recording that other people need to be told about before they can hear it. He had calibrated his equipment himself for 23 years, and the calibration was in his hands as much as in the machines. I have been learning to see what he saw when he looked at a proof. Felix has been patient about teaching me what to look for, and Camille has been patient about explaining why certain customers want certain things and what my father's particular approach to those wants had been. I am building a version of the knowledge that my father had after 23 years, which means I am at the beginning of a long process, and I know it, and I am not impatient about it. He was not impatient about it either when he started. He measured twice. He learned the things that needed to be learned before he acted on them. I am trying to approach it the same way he approached it, which is to say with the specific combination of care and confidence that comes from knowing why you are doing what you are doing and from having the documentation that confirms it is yours to do. The windows of the shop are clean. I wash them myself on Monday mornings before opening because my father kept them clean, and because I understand now exactly what he meant when he said that a print shop with dirty windows does not respect itself. I have told Camille this, and she said your father would appreciate that. I said I know. She said he would also tell you to get a squeegee because paper towels leave streaks. I said he would be right about that. She said yes. She said he usually was. Felix also told me something about my father that I have been thinking about since. He said in 8 years my father had never signed off on a job without looking at it himself. He said it did not matter how busy the day was or how many jobs were queued. Every job that went out the door had been looked at by Gregor first. He said, I am going to hold you to the same standard. I said I accept that. He said good. He said the customers will notice if you do not. I said I know. He said your father noticed and that is why they stayed. I said I understand. I do. The hearing. I do not expect that we will soon. What he did required a specific kind of decision to do, and I have not arrived at the part of processing this where I can hold a conversation that begins from anything other than the fact of that decision. I may get there. I hold the question with the patience that significant questions require, and that I did not have when I was younger, and that I seem to have more of now. I want to say one thing before I go. I have been asked by people who know the story whether I was angry. Not about Stefan specifically, but about the situation. The fact that something like this can happen. The fact that someone can file a fraudulent document with the Secretary of State and the office does not catch it because the office does not investigate the substance of transfer authorizations, and the filing becomes a live public record that creates uncertainty about ownership until a court voids it. Yes, I was angry about that. I am still somewhat angry about that. The system that is supposed to protect business records also creates a vulnerability that someone who knows how it works can exploit because the system trusts the filer. The counterweight to that vulnerability is exactly what I had, which is a set of documents that say what they say loudly enough that a court can follow them clearly and quickly. Owen said to me once during the proceedings that the best protection against fraudulent filings is documentation that makes the fraud immediately visible to anyone who looks. He said we are fortunate in this case that the fraud used a name that produced that visibility automatically. He said in other cases the visibility requires more work to establish. He said the lesson is not that this always works out. The lesson is that the documents you keep are what makes it possible for it to work out when the fraud contains a mistake that can be documented. He said Stefan's mistake was using a name that a public record could contradict. He said without that mistake, this would have been significantly harder. I said, I know. I said, I am grateful for the mistake. He said, I think you are also grateful you kept the documents. I said, yes. I said, both things were necessary. He said, that is usually how it works. Not about Stefan. Not about the ruling or the referral to the prosecutor. About the name change record. About the court order that had been sitting in a folder in my documents file for 6 years that I had last thought about when I updated my driver's license and social security card and had not thought about since. I kept it because it was a legal document, and I keep legal documents because that is a habit I developed at some point in my adult life and that I maintain without always knowing why. I did not know the day I filed it that I was building evidence for a future case. I knew that I had legally changed my name and that the court order was the proof of that, and that legal proof of things should be kept. The proof sat in a folder for 6 years and it waited. When I needed it, Owen asked for it, and I emailed it in about 45 seconds from my documents folder on my laptop, and it said what it had always said, which was that Lara Kovacs ceased to be my legal name on a specific date in March of a specific year, and that date was 6 years before the signature on the transfer authorization, and that was enough. Thank you for staying until the end. If this story made you feel something, write it in the comments. I read every single one. And if you want to hear the story of a woman whose neighbor had been using her deceased mother's identity to collect pension checks for 2 years and what the return mail notice in a mailbox revealed, it is waiting for you in the description below. Click it. Until next time, take care of yourselves. And if someone sends you a certified letter claiming you signed something, look very carefully at what name appears under your supposed signature. If that name is not the name you currently hold, what you are looking at is not an administrative nuance. It is a choice someone made. I want to tell you about the print shop in a way that communicates what it actually was and why what happened to it felt like the specific kind of loss it was. Dalton Street Print and Design occupies a ground floor space in a building that has been there since the 1960s, in the part of Cleveland where the commercial streets have the particular texture of places that have survived through several different economic eras without being substantially redeveloped. The storefront is about 1,500 square feet with large windows that look out onto the street and that my father had always kept clean because he said a print shop with dirty windows suggested a print shop that did not care about how things looked. And a print shop that did not care about how things looked was not the kind of print shop anyone should trust with their materials. He was consistent about the windows. In 23 years of running that business, he had never once let the windows go more than a week without attention. My father's approach to the business was specific in the way that people who have built something from savings rather than investment tend to be specific. He had a saying that I have heard from other people since, and that I think belongs to a category of practical wisdom that gets discovered independently by people who have done careful work for a long time. Measure twice, cut once. He applied this not just to the actual materials, though he applied it to those too, but to every decision that mattered. He measured twice before he hired someone. He measured twice before he bought a piece of equipment. He measured twice before he committed to a client relationship that seemed complicated. And then when he had measured twice, he moved with a decisive confidence that I found enormously reassuring as a child, and that I find myself trying to replicate now as a person running the shop he built. The shop had two main employees when my father died. Camille had been there 9 years and handled customer relations and the front desk and the management of the job queue with the particular combination of systematic precision and personal warmth that keeps customers coming back to small businesses when they could go to a chain instead. The other long-term employee was a press operator named Felix who had 17 years of print production experience and who had been at the shop for 8 years and who ran the production floor with the specific technical knowledge that my father had recognized as rare when he hired him and had structured the compensation to retain. There were also 2 part-time employees who handled delivery and finishing work. The 4 of them together constituted a team that had been working together long enough to not need constant management, which is the specific kind of team that takes years to build and that cannot be simply replaced if it disperses. After the certified letter arrived, and I want to tell you about Camille in a way that goes beyond what I have already said because she deserves more than the summary I have given her. She is 44 years old and she has worked at the shop for 9 years, and she has the specific quality of a person who has decided that doing her job well is a form of self-respect and who does not require praise to maintain the standard she has set for herself. She was the person who held the shop together in the days between my father's death and the restraining order. She managed Stefan's visits with a combination of politeness and firmness that was, by her description, not easy, and that she maintained anyway because she had decided that what my father had built deserved someone standing in front of it correctly. She said that to me directly in a conversation we had the first week I was at the shop full-time. She said, "I did not know you well before this, but I knew your father well, and I knew what he intended, and I was not going to let something that was not right happen without doing what I could to slow it down." I said, "You did more than slow it down." She said, "I just asked for the documents and said I would wait." She said, "Most people will not do what they are not authorized to do if you ask calmly for the authorization and do not indicate that you will accept the answer. No documentation is necessary." I said, "Where did you learn that?" She said, "From 9 years of working for a man who believed in doing things right and who said it out loud often enough that it became part of how I thought about my work." She said, "Your father was a good teacher." I said, "Yes." I said, "I am trying to learn the same things." She said he would be glad to hear that. I said, "I hope so." She said, "Then let us get back to work." And we did. Owen had filed the emergency application and the restraining order had been granted. I went to the shop. I had not been inside since the day after the funeral when I had gone to collect some of my father's personal items and had not been able to stay for long because the specific quality of absence in a place where someone was usually present is one of the more difficult things to be in the middle of. I went back after the restraining order because I needed to understand what the current state of things was, and because Camille had called me the day before to say that Stefan had been in twice and that things had been uncomfortable and that she and Felix were glad I was coming. I walked in and Camille looked at me from behind the front desk with the specific expression of someone who has been managing a difficult situation with professionalism and is very glad to see the person whose problem it actually is. She said, "I am glad you are here." I said, "I am glad to be here." She said, "Your father would be glad you are here." I said I know. She made coffee and we sat at the desk and she told me everything Stefan had done in the 12 days between my father's death and the restraining order. He had come in 4 days after the funeral and had told Camille and Felix that he was the new owner and that they would be receiving new employment contracts within the week. He had taken photographs of the equipment. He had asked for access to the accounting software that Camille managed. She had said she was not comfortable providing access without documentation of the ownership transfer, and that she would need to see the relevant legal documents before she could give anyone access to the business accounts. He had said the documents were in process. She had said she would wait for the documents. He had come back 3 days later and told her again that he was the owner and that her continued employment was contingent on cooperation. She had said the same thing she had said before. He had not returned after that because Owen's restraining order had arrived in the interim. I want to tell you about Owen Park because he is central to this story in a way that goes beyond the legal work. Owen had been my father's business attorney for 11 years. He had drafted the original LLC operating agreement and had updated it 3 times as the business circumstances changed, including the specific update 3 years before my father's death that had been prepared explicitly to document the succession to me. Owen was therefore not just a lawyer I had called in a crisis. He was a lawyer who had spent 11 years understanding what my father had built and what my father wanted to happen to it. When I called him with the certified letter, he already had the context. He did not have to be briefed on the background because he had been the person who documented the background. He told me something in our second conversation that I have thought about many times since. He said the specific choice to use the old name on the forged authorization was the kind of choice that looked like it would work without investigation. He said whoever made it had looked at the business documents, found Lara Kovacs on the founding documents and the operating agreement, and had concluded that using that name would appear continuous with the business history and would not raise questions with the Secretary of State's filing office, which does not conduct substantive investigations of transfer authorizations. He said the flaw in the logic was that an Ohio name change record is not something you can account for if you have not known about it and checked it, and that anyone who had known about it and checked it would also have known the name was invalid and would not have used it. He said the absence of the check was the evidence of the problem. If you were trying to do this correctly, you would verify the signer's current legal name. If you did not verify the signer's current legal name, you were not trying to do it correctly. Stefan had not known about the name change or had not checked it. Either way, the record existed. Court orders in Ohio are filed with the clerk of courts and are accessible through the county's online record system. The record of my name change had been sitting in a public database for 6 years. It had been there the entire time the business had been operating. It had been there when my father updated the operating agreement. It had been there when he died. It had been there when the fraudulent transfer was filed. It had been there when the certified letter arrived. It was there when Owen searched for it, which took him approximately 10 minutes, and it said what it had always said. I want to tell you about my father. I want to tell you about my father's arrival in Cleveland because it shaped everything that came after, and because understanding that context makes the shop mean what it means. He came from Budapest in 1985 at 24 years old with the specific capital of someone who has prepared carefully for a move that cannot be undone. Some money, some language, specific technical skills, and the particular determination of a person who has decided that the right context for their abilities is not the context they were born into. He had trained in printing in Hungary at a technical institute and had worked in a state printing enterprise for 2 years before leaving, and had the specific knowledge of offset lithography that was transferable across national contexts, and that he had correctly understood would be more valued in Cleveland's commercial printing market than in the institutional context he was leaving. He found work within 3 weeks of arriving. He worked for other people for 4 years, and in those 4 years, he saved specifically and learned everything about running a print shop that could not be learned from the production side. He learned customer acquisition and job pricing and equipment financing and lease negotiation and the specific kind of patience required for building a client base from zero. He opened Dalton Street Print and Design in 1988 when he was 28 years old, and he ran it for 23 years until he died. And in those 23 years, the shop never missed a payroll and never had to apologize for a job that had not been done correctly, and never lost a long-term client relationship because of anything under his control. I know this because he told me. I also know it because Camille told me, and Felix told me, and Gerald the lawyer told me, and a woman named Beatrice who has been having her wedding stationery and then her event stationery printed at the shop for 16 years, told me when she came in 2 weeks after I had started and said I was glad to hear a Kovacs was still running things. I said my name is Brennan now, but yes. She said same family. I said yes. She said then I will keep bringing my business here. I said thank you. She said your father would be pleased. I said I hope so. I said I intend to give him reason to be. And what he understood about documentation because it is relevant to why the succession documents existed in the form they existed. He was a person who believed in putting things in writing. He had come from a background where things were not always put in writing, and where the absence of documentation had created difficulties that he had decided he would not recreate in his own life. He kept meticulous records. The shop's accounting was current to the day. The equipment maintenance logs were complete for 23 years. The employee files were organized and accurate. The client contracts were filed chronologically in physical binders and backed up digitally. When he updated his succession documents 3 years before his death, it was not a crisis response. It was a scheduled review that he did every few years, because he believed that documents should be current and that keeping them current was part of running a business correctly. He had told me once, when I was about 25 and helping him with a filing project at the shop, that a business that does not keep its records is a business that does not respect itself. I had found this a slightly strong way of putting it at the time. I find it exactly right now. The records he kept are what I am working from. The succession documents he maintained with Owen are what the court relied on. The updated operating agreement that he had prepared 3 years before he died, because he believed in keeping things current, was the document that established beyond any dispute that he had intended the business to be mine and had taken the specific legal steps to make it so. He had measured twice. He had put it in writing. He had kept it current. The combination of his habits and my court order was what the case was built from and the case held. I want to say something about what the first month of running the shop was like. I am a person who had a different career before this. I had been working in graphic design for a marketing firm for 4 years, and I knew the design side of what a print shop produces, but I did not know the production side, and I did not know the operational side, and I did not know the customer relationship side in the specific way you know it, when you are the person responsible for maintaining those relationships. I learned things very quickly because there was no alternative, and because Camille and Felix were generous with their knowledge in a way that I think came from a specific loyalty to my father, and a decision that the best way to honor him was to make sure his successor succeeded. They taught me without making me feel that I was being taught, which is the most graceful form of instruction. The customers have been similarly generous. Several of them have stopped in the first weeks to introduce themselves to me and to tell me things about my father that I either already knew or that were new information, and all of it has been told with the warmth that people use when they want you to understand that they knew someone well and respected them. A man named Gerald who runs a small law office nearby and who has been having his letterhead printed at the shop for 18 years, told me that your father made the letterhead 3 different times until the kerning was exactly right and refused to charge me for the first 2 tries, because he said they were his mistakes for not getting clearer specifications at the start. He said that was not how most printers operated. He said he has been a loyal customer for 18 years because of that first interaction. I said I understand. I said I am going to try to run it the same way. He said I think you will. There is something I want to say. I want to say something about the Ohio Secretary of State filing and what it is and why it matters for anyone who owns a business interest or expects to. In Ohio, when an LLC membership interest is transferred, the parties can file an amendment with the Secretary of State reflecting the change. The office accepts these filings and records them, and they become part of the public record of the business. The office does not verify that the authorization signatures are genuine. It trusts the filer. This is a practical necessity for a high-volume filing system, and it creates a specific vulnerability that someone who knows how the system works can exploit. The protection against this vulnerability is not a change in the filing system. It is the existence of documentation that contradicts a fraudulent filing clearly enough to be useful in a court proceeding that can void the filing after the fact. The court system is the backstop. Owen explained this to me in our third call, and I found it clarifying rather than alarming because the backstop existed and I had the documentation to use it. He said, "You should know that as a new business owner, you should check the Secretary of State's business filing page for your LLC every few months." He said, "It takes about 2 minutes and it will show you any filings that have been made regarding the business." He said most people do not do this, and most of the time it does not matter because nobody has filed anything fraudulent. He said the times when it matters significantly, and the 2 minutes every few months is a very small cost for the peace of mind of knowing the public record of your business matches what you believe it to be. I have set a calendar reminder for the first of every quarter. 2 minutes. Secretary of State business filings. Check the record. My father would have done this. He was the kind of person who checked the record. I am trying to be the same kind of person. About Stefan, that I have not fully said yet, and that I think belongs in this story because leaving it out would make the story less accurate than it deserves to be. Stefan and my father had a relationship that was warm in the way of relationships between an uncle and a nephew that do not have significant conflict and that are maintained through regular contact and genuine affection without being particularly deep. My father was generous to him. He had given Stefan the delivery work when he needed income. He had let him manage the social media accounts when Stefan had presented it as both helpful and professionally relevant to Stefan's interests. He had included him in family events and spoke of him with the casual warmth of someone who had decided that family relationships were worth maintaining and who did not require them to be profound in order to value them. I do not think my father suspected that Stefan would do what he did. I do not think he believed it was possible. I also think that Stefan, in some version of his own accounting, believed he had a claim. Not a legal claim, not a documented claim, but a felt claim. The specific claim of someone who has been present and helpful over a period of years and who looks at the distribution of assets and finds that his presence and helpfulness have not produced the share he felt they entitled him to. I understand this as a human dynamic without excusing what he did with it. The felt claim did not authorize a forged signature. The felt claim did not authorize the use of a defunct legal name on a business transfer filing. The felt claim was something that could have been expressed in a conversation, or in a probate proceeding, or in a direct communication to me about his perspective on the succession. He chose a different method. The method left a record that was easy to follow. I also want to tell you something about the week between receiving the certified letter and the restraining order being granted. It was one of the stranger weeks of my life because the specific combination of grief and bureaucratic emergency and the particular disorientation of dealing with something that should not be happening while you are also grieving the person whose death created the conditions for it creates a quality of experience that I can only describe as a kind of strained alertness. I was not sleeping well. I was going over the same facts repeatedly in my mind to make sure I had them right. I was calling Owen every other day for updates. I was simultaneously trying to process the loss of my father and trying to protect what he had left, and the two things pulled at each other in ways that were not cooperative. The person who helped most during that week was not a professional and was not a family member. It was Camille. She called me every day not to ask about the legal situation. She understood that I could not discuss the details of the ongoing proceedings, but to tell me about the shop. She told me about what jobs were coming in. She told me about what Felix was working on. She told me that a long-standing customer had asked after my father, and she had told him that Gregor's daughter was going to be running things, and the customer had said good. She told me these things in the specific understanding that a person who is trying to protect a thing needs to be reminded of what the thing actually is while they are protecting it. She was keeping me connected to the shop while I was doing the legal work that would determine whether I could return to it. That was a generous and specific form of care, and I have not forgotten it. I want to say something about name. There is one more thing I want to tell you about the name change and what it meant to me and why I have thought about its role in this story with a specific kind of attention. The name change was a personal decision I made when I was 23 years old for reasons that were important to me and that I am at peace with and that I will not go into here because they belong to a part of my life that is mine to hold. What I will say is that the decision produced a court order, and the court order became a public record, and the public record sat in a county database for 6 years doing nothing until it was needed. I did not make that decision for protective purposes. I made it for personal reasons that had nothing to do with business succession or legal documentation or the possibility that someone would one day forge my signature using the name I had left behind. The connection between that personal decision and this legal outcome is one of those connections that you cannot plan for, and that become visible only after the fact when you can look back and see the chain of decisions and outcomes that led to where you are. I changed my name. The court recorded it. Stefan used the old name on a forged document. The court record contradicted the document. The document was voided. The shop is mine. That chain is not a chain I could have assembled in advance. It assembled itself from things I had done for other reasons and things he had done for his reasons and the public records that connect them. I think about the case sometimes as a reminder that the things you do carefully for your own reasons have a life beyond the reasons you did them for. Documents you file correctly do not expire in their usefulness just because you have stopped thinking about them. They are there. The record is there. When someone makes a choice that the record contradicts, the record is still there and it still says what it says. This is a feature of public records that I find genuinely useful to understand and that I have found myself telling people about in the months since the ruling. Not because I think everyone needs to worry about forged signatures, because I think the records you keep and the records that exist about you have a protective function that is not obvious until you need it. Keep the records. The records will be there. Change records and what they are and why they matter in ways that most people do not think about. A court-ordered name change in Ohio creates a public record in the Clerk of Courts database. The record includes the date of the order, the name as changed from, the name as changed to, and the court's certification. It is accessible to anyone who searches for it. It is also, and this is the part that most people do not think about, a record that establishes the legal identity of a person at a specific moment in time. It says, on this date, this person's legal name became this. It means that anything signed under the previous name after that date is not a valid signature by that person in their current legal capacity. This is not a loophole or a technicality. It is the fundamental mechanism by which legal identity works. Your legal name is what your legal records say it is at the moment of signing. If someone signs under a name that has been legally changed, the signature is not theirs in the legally operative sense, regardless of whether the handwriting matches. The legal name is not the handwriting. The legal name is the identifier that connects the signature to the legal person. If the identifier has been changed and the signature uses the old identifier, the connection is broken. Owen explained this to me in about 4 sentences in our second call, and it was one of those explanations that felt both obvious after the fact and that I would not have understood as clearly without someone who does this work explaining it clearly. He said it is the kind of thing that a non-lawyer might think of as a technicality, but that a judge understands as the entire foundation of what makes a signature valid. A judge who has been determining what documents mean for years understands that a signature is not just a mark. It is a legal act by a legal person. The legal person is defined by the records. If the records say the name used does not belong to the person you claim signed, the signature does not belong to that person. Judge Merritt had been on the bench for 16 years. She understood this in one paragraph. I want to tell you something that Owen said to me after the case was closed and the business had been fully transferred into my name and the records had been corrected and we were wrapping up the last of the administrative work. He said, I have been doing business and estate law for 22 years, and this is the case I will describe most often when people ask me why proper documentation matters. I said, why this one specifically? He said, because the documentation was so clean and the fraud was so visible and the resolution was so direct. He said, most of the cases I work are not like that. Most of them involve ambiguous documents or missing records or competing claims that have some validity on both sides and that require significant work to resolve. He said this case was not ambiguous. The succession documents were current and clear. The name change record was public and specific. The fraud used a name that a public record directly contradicted. He said the combination of your father's habit of keeping his documents current and your habit of keeping your personal records in order produced a case that could be resolved in 6 weeks rather than several years. He said he wanted me to understand that not all of his clients have what I had. He said many people come to him with real grievances and insufficient documentation, and the grievances are real, but the path to resolution is much harder. I said, I understand. He said, your father was a careful person. I said, yes. He said the case is in part the record of a careful person's habits protecting the thing he built after he was no longer there to protect it himself. I sat with that sentence for a long time. The case was in part the record of my father's habits. He measured twice. He kept his documents current. He used an attorney he trusted for 11 years. He updated the operating agreement when it needed updating. He filed correctly. He left a record that said clearly what he intended, and the record protected what he intended after he was gone. That is the inheritance that no forged document could reach. The habits of a careful man doing his work correctly for 23 years and trusting that the record would hold. The record held. I will say that again because it is the thing I most want people who are watching to take away. The record held. Not because I did anything exceptional, because my father did his work carefully for 23 years and kept the documents current and used an attorney he trusted and updated the paperwork when it needed updating. And because I had a folder on my laptop with a legal document in it that I had filed away 6 years earlier and had not thrown away. Those are not extraordinary things. They are habits. Ordinary habits that exist or do not. In this case, they existed. In this case, that was enough.